Yeah, thank you very much, Samson. The Attorney General did nothing wrong when he wrote a letter to the registrar or the Chief Justice to abridge the time for hearing the matter. But the question, to put the question that way, would also mean that we have left out some very fundamental, concerns or issues which need to be discussed or need to be considered. There's something called discretion in the Constitution of Ghana. Discretion is very essential to leadership. I mean, if you're in government or if you're a public official, you definitely would need to have some discretion. Discretion is actually the essence of power. So anyone who has power necessarily must have discretion to go one way or the other. So that is the issue on discretion. However, the ultimate essence of law is certainty and predictability. So when, for example, we say the first law of physics or the law of that, what we are basically saying is that there must be, the thing is so certain that it should cut across circumstances and it should apply evenly across the border. So that is the fundamental essence of law. Now, the reason why I'm raising this issue is that the Attorney General definitely has a discretion to abridge or to cause a case, the time for hearing a case to be abridged. And he ought to do that by writing to the CJ or the registrar.
First of all, substantively, there was no time for the hearing. So was there anything to be abridged?
Well, I was going to go to that. And that would have to lead us to the changes in the practice in the Supreme Court. And you remember, I think later last year, there was a directive from the Chief Justice, which indicates that when you file a case, contrary to the previous practice, where you'll be given a specific date on the phase of your motion before the motion even goes out. This time around, we don't have dates on the processes. Rather, there is a note which is often attached indicating that the Chief Justice the registrar would issue a hearing notice. And the note, that statement itself is not clear.
Within 14 days upon service.
Yeah, upon service. And then it says upon request again. So the question is upon whose request, and how would the person who has issued the motion, know that there has been a service on the other party for him to make that request? And if it's supposed to happen within 14 days, then the notice itself is vague. But that is where I was talking about discretion and some of these directives. So the essence of law is certainty, and that's why we have something called constitutionalism. If you have a discretion to do something, the purpose of law is to, as much as possible, limit the discretion so that we don't have some of these things coming where discretion may be exercised capriciously, wrongly, or even vaguely. So what we seem to have here is that we have increased the discretionary power that we are giving in the administration of justice, to the extent that previously, while both parties would automatically know the date of hearing, and then if someone wants it to be heard earlier than that date, will make a formal application to the court, which application will be served on both parties, and then the argument will be taken as to whether there should be an abridgment or not, and the two parties are present to discuss or argue that for the court to make an informed decision. Now, the current arrangement actually takes away any of these things. So a person will write a letter to the Chief Justice. The Chief Justice would listen to only that person's concern and either abridge the time or refuse the abridgment. And then at the end of the day, a date is fixed, which may or may not be convenient for the other party. And if it's unable to come to court, the case will be heard. So if we talk about whether the AG can do that or has the right or power to do that, indeed, he has the power to do that and it's the right thing to do. However, we have created a system which basically is making it impossible for a hearing to be fair, which is fundamental to our jurisprudence, that whenever a decision is going to be taken, whenever a case is being heard, even every process filed in the case, whether the party is even concerned or not, should be served so that there will not be a situation where a decision will be taken.
So what's the
in
problem?
the absence of the
What's
other
the problem? The Attorney General writes a letter to the court or to the Chief Justice or the Registrar asking that I want an expedited hearing of the application. Then a date is set for, that was Wednesday, the 27th. Now, when that date is set, all parties are notified about the Wednesday hearing, except that there was some problem with the plaintiff's service on the plaintiff. But as we know, if a bailiff comes to you, tries to serve a process, and you try to evade, once they drop it and you are seeing it, they drop it before you, it is good service. So what is the point here? You write a letter, but the date for the hearing is communicated to all the parties before the case is heard. Is that not it?
That is so.
So what's the problem?
What's your question again? What is the problem?
What's the problem? You raise questions of fairness.
Yeah, my question goes to, so what happened is as a result of the new regime of getting a date for processes in the Supreme Court. I mean, you would agree with me that if it were the old regime where the date would be printed on the process, then the AG would have filed an application for what? Abridgment of time. And you raised the issue that there was even no time. So how do you file an application for abridgment? That is exactly why the AG couldn't file an application for abridgment of time and had to what? Write a letter, because the new regime doesn't give you any basis to even make that kind of application for abridgment of time, because there's actually no time to abridge. So, and once the letter went, on a very good day, the determination of whether the abridgment should be granted, okay, must be subject to argument. Is that not so? I mean, is that not so? If you want to take a decision whether to abridge, because we know that it should be within 14 days after service, okay? And within that 14 days, we are assuming that all the parties will know the day on which the process has been served, and they will start counting what? There are 14 days. What it means is that then the party would have to apply to the courts, to find out when the other party had been served. And that inquiry, you and I know, can take a couple of days. So what I'm saying is that the confusion happening now is not necessarily because of what the Attorney General did by writing a letter, and it's also not necessarily because the date has been determined and notice has been served. It is because of a bigger issue, which is creating a situation where there's very little, not hearing of both sides for a decision to abridge time to be taken. And you see, I'm making this point because most of the time we pick on specific instances without looking at the bigger, picture. So what I'm saying is that this problem would not have come up everywhere in the regime which gave both parties the opportunity to file for an abridgment, and the other party will be heard, an argument to be taken in respect of the abridgment. So that is the point I'm making, not necessarily to say the AG was right or wrong, or not necessarily because the date was given or notice was not given fairly. But this problem, you and I know, and I believe my senior in the studio, Honorable Attache, would agree that this situation will not happen if we were having the old regime in place. So I think it is time that we probably have to reconsider this, the new regime of filing thing. That is what I think the issue should be.
So, when you look at the process of injunction applications, the injunction application or the notice comes together with an affidavit and your arguments, what we call the statement of case. The opposing side will also file their facts in the affidavit and then file their arguments in the statement of case. Very often, judges will say, that is enough. I don't want to hear any more argument. I can give a decision. Is there a question of lack of fairness because Dafiamakpo and his lawyer were not in court?
No, I think the question is not lack of fairness because they were not in court. I mean, the court could have actually decided the motion without hearing any argument. I think that is the position of the law. The court could have looked at the affidavit evidence alone and make a decision.
Or without the motion being moved. It is settled law that the judge can decide it.
Yeah, the court can decide even if the motion is not formally moved.
That's right.
And these days, we are even advised not to move it in terms of argument, just move it, by what, a formal, So that is the position of the law. The court could have decided that. But we would agree also that the issue about being present is now what is in dispute because the people are, the appellant or the applicant are saying that they were not aware. They are claiming they are not aware of the date. And even though the court was satisfied that they have been duly notified, my point is that once the other party is aware and has come, and that is why sometimes you would agree that a process, a decision of the court will be set aside, that the other party is not given an opportunity to be heard. Now, after the case has been decided, assuming that what happened in court, there's now new evidence that the other party, that is the Fiameco, has not been properly served. You would agree that that would be a valid ground for vacating the decision of the court.
So,
right. I'm just saying that assuming.
Right. So my question so far is to come to the point where I'll ask you to educate the public. Was anything amiss in the application being determined and dismissed? Did something go wrong?
No, you cannot sit at home, right? And draw. The presumption is that once the court considered all this, then nothing has gone wrong. So in terms of the procedure that I know, in terms of all the things, my knowledge of the law, nothing has gone amiss as at what we have on the records of the court. That is the point I'm making.
Right.
But then the question is, you see, the question ought to be bigger than what we are limited to what the rules of court say. But we also know that administration of justice, as we say, justice must be seen to be done, not
manifestly
just done, but it must be seen to be done. Because when you administer justice in such a public interest manner and is raising legitimate concern about whether there was a fair hearing, the answer to that kind of objection is not necessarily to rely strictly on rule of law. That is why I began my submission by looking at a bigger issue than this.
Okay.
So, nothing is wrong as what has been done, but there are concerns which I think are legitimate based on what regimes we are running.
Okay. What will be your topmost pick on the concerns that have been raised? I'll not predict any one of them for you. Which will be your major concern in this case?
No, my major concern is that, you see, and it has to do with the way the Attorney General is going about the issue, the matters. So, for example, it is within the Attorney General's discretion to decide which case to abridge, which case to abridge. So there are two cases. In both of the cases, he's defendant in case 1 and case 2. Now, the question is, what informed the Attorney General to choose case 2 in respect of which he asked for abridgment of time without doing the same in respect of what? Case 1. That obviously is a question which needs to be explained because, as I understand it, the Attorney General is not an Attorney General he's not a partisan Attorney General in terms of Attorney General is for the Republic. He represents all of us in cases when Attorney General is even in court. He could be called upon to give his opinion on matters, and his words basically are also valued more than any other lawyer in the case. So, and that is based on the understanding that an Attorney General is a person who has the whole public interest, is the repository of the public interest as far as law is concerned. And that is why he's also the Minister of Justice. So the question that I would ask is, why would he choose to abridge one of the two cases when he is defendant in both? And both of them have, significant impact on administration of government, both in the legislature and in the executive. That is my concern in this.
I am Attorney General. There are 1,001 cases before me. I determine which one is of, pressing need to attend to. Why should I be explaining that to you? And don't we know that Parliament was suspended by the Speaker because of what he said was the Dafiamapo injunction? The fact, though, as I keep repeating, is that by the time the Speaker said there was an injunction, there was none. Why should he be explaining to you which of the cases he chooses to want to be heard quickly?
Well, it is not a question of the Attorney General explaining to us, but it's in respect of people, or we the people, asking questions. And when, by the fact that he occupies a public office, when questions of this nature come up, I think there must be some element of explanation that, well, I chose case A to abridge. I abridge the time in respect of case A because of this and these factors, which are not present in respect of what? Case B. That is what we expect to hear, so that the public concerned that he's choosing the side of the debate unfairly or unreasonably would be laid to rest.
But the Attorney General advises the government. And the Attorney General knows where the President stands on the two matters. So was it not a matter of, consequence that he would want to do what the President puts premium on?
Yes, Samson, that's exactly the point. That's exactly the problem. That's exactly the problem that, the Attorney General wrote a letter to the Speaker a couple of days ago. And in the letter, what was he trying to do? He was trying to advise, Parliament on what ought to be done. And that, I think, because he considers it his duty to advise not just the executive, but also anything that affects the government as a whole, because he's the Minister of Justice. Now, the question is, why, if he knows where he stands, if the Attorney General knows where he stands and is proud of where he stands and want everybody to know that I stand with this side of the debate, I am more concerned about not having the bill in question passed. I'm more concerned about the President's interest as against Parliament's interest. Why was he writing the letter he wrote? Why was he seeking to advise the Speaker? Why was he advising the President in particular way? So it is these inconsistencies in his stance. In one way, he seems to represent the interests of the government, as a whole. When I say government, I mean all the arms of government as a whole. In another instance, he seems to be, in the same set of facts, he seems to be more interested in the side of the President than the other side of the debate. And this is what is making people ask these questions. That right. Is it Attorney General for all of us, or is Attorney General for one side?
So address this for me quickly, and then you hold on. I will return to you on a more substantive question, that we know the general principle of law on the effect of served applications for injunction. The general principle of law is that once served, you stop. You don't do anything to overreach the court. But don't you join the exception that is being canvassed and more vigorously by people like Oliver Barker-Vormawor about not using injunctions to stop the performance of a constitutional or statutory duty. But you will come to that later. Now I'm asking, would you say the NDC is justified in any way by attacking the Chief Justice and the courts the way they have done? That she's biased, literally, that she's doing the bidding of the NPP by not paying attention to the applications that were filed on the 7th of March, but rather dealing with the applications that were filed on the 21st and 25th, is it? Yeah?
So the question really is not whether you agree or not. I think the question should be whether you understand the position being taken as from, that is what the position that NDC, has taken. And that is why I began my submission by explaining that there is a more, there's a bigger issue, there's a bigger concern, which is, so the problem did not just come up, the problem is inextricably hooked with something which has nothing to do with this particular case. It is hooked up with something which is new, which has created or has widened discretion. So if you look at it from that perspective, then basically what I'm trying to say is to point out the fact that we need to administer justice in a more, comprehensive manner, and that clearly is an issue which we need to look at, and that is the point I made earlier about.
Yeah, my question to you is, from where you sit, I don't want to read and repeat the statements in the NDC's release. Are they justified? Their basis was that 2 injunction applications were sitting before the court filed on the 7th of March. She ignored those and then decided rather to expedite hearing on those that were filed on the 21st and 25th. Therefore, she's exercising discretion capriciously. These are their words. Arbitrarily, she's being biased, and she's seeking to facilitate Akufo-Addo's agenda.
No, in this particular, case of this particular case, we've just explained that it is not the Chief Justice's, making. Chief Justice has, the registry gives timeline for cases. What we are looking at is an abridgment application or a letter of abridgment which has been brought by the Attorney General, which the Chief Justice has to act on. If there was no application for abridgment in respect of the other cases, I honestly do not see how the Chief Justice is supposed to, know the need for urgency and be able to abridge the time for that. And even if she did that, that would be that would even be capricious in the sense that then is acting out of authority, because there's a general rule that the matter will be brought within a certain amount of time. One person has applied for abridgment, which is before you would have to act on that particular abridgment. So if the Chief Justice acted on that abridgment and there was no application for abridgment from the other, and I'm using abridgment in a vague word, the letter, if there was no letter in respect of the others, I believe that then the Chief Justice would not even have the authority or a legitimate basis for bringing that forward.
Okay, thank you. Hold on there for me now. Let me